people that are out on the highway, we're going to get underway out of respect for all of you that made it in. Thank you so much. I'm Russell Kennedy, Director of the Orange County Human Relations Commission. I have the chair of the commission here, Carol Turpin, and some of our board members. Welcome on their behalf. To start us off, I wanted to ask Lacey Kelly, the Executive Director of the Association of California Cities, Orange County Chapter.
Thanks, Rusty. Well, I'll be brief. I want to thank you guys for coming out tonight in December when there's a lot of holiday parties and things going on, so we appreciate you taking the time. The Association of California Cities, Orange County is a membership group of Orange County cities and their public policy partners within the county, and we work on what we call from the ground up public policy and in a collaborative manner with our partners. And that's sort of an example of what we're doing tonight. I want to thank our partners, the Orange County Human Relations Commission and Rusty Kennedy, and of course, District 4 County Supervisor Sean Nelson, also Chairman of the Board, for showing leadership on this very important topic, which he will queue up, but something that many of our cities and local governments are dealing with is how to protect productive public discourse and try to eliminate some of the abuses that go on with that. So I'm really looking forward to the panel that we have tonight of experts, and with that I'm going to let our Chairman of the Board take over here. So thank you for coming.
All right, well, first of all, thank you for coming. My name is Sean Nelson. I happen to be the chair of the Board of Supervisors here in Orange County. And as you might imagine, I run a lot of formal meetings. I just coincidentally happen to be an attorney, which doesn't mean I'm good at anything. But I have a lot of formal training at being in a public setting and running meetings and understanding what rules and regulations are. But throughout the time that I've been on the board, and certainly serving as the mayor and councilman in Fullerton, we're all familiar with opportunities that come up when people come to what they perceive as a public mic, which doesn't necessarily mean a free-for-all in the first place, although some interpret it to be. But there are always these question marks. What are actually the rules? Where are the limits? What is the limit of what you can and cannot say? Are there topics you can and cannot speak about? There are. The proper introduction for public comment is not come one, come all, this is public mic. It is public comment is available for those items that are not on the agenda, but that are within the jurisdiction of the agency. And jurisdiction has some meaning, and maybe our cast of panelists are going to shed some light on that. But my hope is to learn something tonight, and my hope is for those of you who've been to a lot of formal meetings or run them, that you will as well. But if there are some in the audience, particularly for library board members, school board members, there are not always attorneys present at public meetings. Most of the ones I'm at, there are. Most of the ones I'm at are much more formal, often televised. But you can imagine if you have a group of citizen volunteers, whether they're running your library board or in a little more formal setting elected to a school board, there's no attorney present, and things start to either get way off topic or out of hand. What are these rules? You know, when can someone be asked to sit down, if at all? And I'm curious if there's some of the panel members that just think, hey, your time limit, whether it's 3 minutes, 5 minutes, or 10 minutes, is whatever you feel like saying. Are there times when it's tempting to shut someone down, but not appropriate? Of course. Are there any times when actually it's, although you can't make a person do anything, are there times when an individual really is prompted that you really should intervene? It would be inappropriate to not get involved and either ask the speaker to leave or sit down or refocus their comments, that type of thing. So, you know, with that, I had probably the same idea about the same time as a few other people I found. This is not about one incident, and it'd be a shame if it got focused on that, because that's really not the whole point. The topic is really ripe to have a discussion. Supervisor Spitzer, sort of right about the time, and Supervisor Spitzer's in the back, dressed as casual as he can be other than his pajamas. But welcome, Supervisor Spitzer.
I'm here for the duration, Mr. Chair.
But I realized, you know, I do have an opportunity to serve my community, and with the title goes a little bit of bully pulpit. You know, I could probably bring some people together. And as I started looking into this, I realized that Supervisor Spitzer had already started talking about doing something. Rusty Kennedy as well was already thinking in terms of maybe a slightly different concept, but just the idea of getting folks together and talking about what do you do in these public settings and what are the limits so that those of us who have to run the meetings don't get in legal trouble, don't violate anybody's rights, but also respect the rights of, you know, all of us that have to listen. And if you haven't seen it, I've seen some pretty extraordinary examples of recently, for example, in the County of Orange, we had a speaker that wanted to speak on not only a criminal court case, and we are not the criminal courts, but when the person clarified it was a criminal court case in Los Angeles County. And I remind you, I'm the supervisor of the County of Orange. And it was very obvious that this person felt that this is the public mind. It's okay. No, at least I don't think so. Someone disagrees, which is fine as well. But with that, I hope this is informative. I'm looking forward to it myself. I do appreciate you all coming. And with that, Rusty?
Thanks, Supervisor. Special thank you to Supervisor Sean Nelson, Chairman of the Board of Supervisors, for really calling this together and being our host with ACCOC. Also, Mike Jankel, our County Executive Officer, is here, and tip the hat to you, Mike, for being here. I know these are challenging issues, and you know, we do have a concern shared by many of you, and we basically have a group of really astoundingly interesting characters here for you to meet and hear from. This is essentially organized as a panel presentation, so it's not really a forum and other types of venues. We have a pretty short period of time that we ask people to come, and we didn't serve dinner, so we're kind of on a short fuse for some. But with that, I wanted to introduce you to the panel, and then we'll just let them go through and talk about some of their points. First up is going to be Manoj Mate. He's a law professor at Whittier Law School, teaches constitutional law, international and comparative law, and election law. Has his JD from Harvard and his PhD from Cal Berkeley. Next to him, Michael Houston is the city attorney of Anaheim, supervises the legal department of 24 attorneys, including the 12 that give advice and representation for the city council and its departments, and a prosecutorial division with another dozen attorneys. Here to my right, Bardis Keeney is the staff attorney in the Orange County. Did I pronounce that correctly?
Yes, you did.
The Orange County office of the ACLU of Southern California. He works in areas of voting rights, civic engagement, First Amendment, racial justice, and immigrant rights. Next to him is my police chief, Dan Hughes of Fullerton. Dan has been in the Fullerton PD since he was born. Shortly he became a cadet right out of high school, Sunny Hills High School in Fullerton, of course, and is now the police chief, has a master's from the Cal State Long Beach, as well as various other degrees from the International Association of Chiefs of Police. And let's see, Rabbi Rick Steinberg is the commissioner appointed by Supervisor Spitzer to the Orange County Human Relations Commission. And he's the senior rabbi at Shir Ma'alot, a congregation in the city of Irvine. So I think that's our group, and we're going to start off asking Professor Mate to begin.
Well, thank you, Rusty, and thank you to Supervisor Nelson and to everyone who helped organize this panel and for inviting me to this event. I also want to thank the other panelists today for sharing their time and expertise as well on this most important issue. Now, I just finished teaching constitutional law this semester last week and gave my students their final exam, ironically enough, this morning. So in some ways, if it seems like I'm teaching again, you'll have to pardon it. It has to be knocked out of your system, I think. I promise there won't be a final exam or anything of that sort, and I won't call on any of you as I do in my classes. So in my brief remarks today, I wanted to present an overview of First Amendment doctrine to help frame some of the issues that the panel will cover today, and specifically how it applies to the issue we're discussing today, the extent to which county and city governments, other public agencies may regulate hate speech and other forms of comparable speech. And I really want to focus broadly on understanding the standards that courts use, different categories of speech and how they are viewed and treated, and conclude by examining how federal courts have analyzed government restrictions on hate speech in council meetings to suggest how these decisions might provide guidance in our discussion today. Now, broadly speaking, courts engage in a three-part analysis in free speech cases, and this is, again, a background overview, examining, first of all, whether or not a claim involves protected speech. Secondly, what is the nature of the forum that you're dealing with? And finally, what are the justifications for exclusion from the forum, and whether or not those satisfy the requisite standard that applies in that case. And generally speaking now, First Amendment jurisprudence distinguishes between two types of restrictions. The first is content-based restrictions, and the other is content-neutral. Content-based restrictions, of course, are presumptively considered invalid and are reviewed under strict scrutiny. These laws must be narrowly tailored to advance a compelling governmental interest. A subset of this is viewpoint discrimination, when you're singling out a particular set of views based on the viewpoint of the speaker. In contrast, content-neutral restrictions, which include time, place, manner restrictions, are reviewed under a lower degree of scrutiny, intermediate scrutiny. Now, in terms of the categories of unprotected speech, now there are certain categories of speech that courts have found to be unprotected, that do not receive a higher level of protection. These include fighting words, which include speech that is directed at another and likely to provoke a violent response, true threats or threatened violence, the incitement of illegal advocacy, obscenity, pornography, libel. Now, with each one of these categories, there are caveats, of course, which many of the speakers may get into. And I don't want to paint this too broadly with a broad brush, but just to generally acknowledge that there are certain categories that receive lower levels of protection. And previously, in earlier jurisprudence, the conventional approach had been that the government had more latitude to prohibit and regulate speech within these categories of unprotected speech, possibly in the area of hate speech. But since the court's decision in RAV versus St. Paul, the court has now indicated that generally content-based distinctions within these categories of unprotected speech must now meet strict scrutiny, right? So the terrain has changed quite a bit with regard to some of these categories, particularly hate speech. So while there is what some call a fighting words exception to the First Amendment, courts have been unwilling to recognize a hate speech categorical exception to the First Amendment, and the RAV decision indicates that the current court appears to be unwilling to move in that direction. Now, there's also a rich body of jurisprudence dealing with how universities and colleges
talking to an audience of lawyers.
Attempt to regulate hate speech. And the short answer is that universally, all of these efforts, for the most part by universities and colleges, have failed. Courts have invalidated universities and college efforts to regulate and restrict hate speech on a number of grounds, mainly overbreadth and vagueness concerns. So we have we have one analog to compare to, right? And that's the domain of universities and colleges. So when we're thinking about city government and county government, in terms of the forum level of analysis, courts have recognized that city council meetings, county meetings, tend to be construed as limited public fora, which has important implications for the way in which we view and articulate free speech rights. I'm sure this will be a subject of great discussion as we get into the rest of the panel. Now, real briefly, I just want to touch on three cases which I think may guide some of the rest of the discussion today. And based on sort of my take on the jurisprudence that others have written in this area as well, the governing standard that applies to the particular area we're going to discuss today was set forth in a case called White versus City of Norwalk. And essentially, other decisions have addressed this as well, but in this case, the court held that even in a limited public forum, like a city council meeting, the First Amendment does tightly constrain government power. Speakers may be removed only if they are actually disruptive, right? So this actual disruption standard is sort of this governing standard that courts, the federal courts, the Ninth Circuit in particular, has applied to, right? You must have actual disruption. And in that case, in White versus Norwalk, The court explained that the speech must disrupt, disturb, or otherwise impede the orderly conduct of a council meeting before a speaker could be removed. The Norwalk Code in this case prohibited the making of personal, impertinent, profane, insolent, or slanderous remarks. Now what's interesting is that the court in this case upheld the City of Norwalk's code, ruling that their code actually required evidence of actual disruption to expel a speaker. Now there's a certain way in which they construed the statute, which I'm not going to get into, but essentially this high level of actual disruption was applied, and the court found that that was met. Now, two more recent cases that are provide more guidance on the White versus Norwalk actual disruption standard are the Acosta case, which was a case that many of you may be familiar with, involved the city of Costa Mesa, and the Norse case, which involved the city of Santa Cruz. I'll briefly touch on the Acosta case here. In the Acosta case, the court dealt with a challenge to Costa Mesa's municipal code, section 2-61, which made it a misdemeanor for members of the public to speak at city council meetings, to engage in disorderly, insolent, or disruptive behavior. So very similar language to the language we found in the earlier case, in the White versus Norwalk case. And in this case, Benito Acosta was removed from a Costa Mesa City Council meeting for an alleged violation of the ordinance. This was largely a protest in response to the city's entering into an agreement with ICE, Immigration and Customs Enforcement, to have its police officers be designated immigration agents with the authority to enforce federal immigration laws. And essentially what happens in this council meeting is that Mr. Acosta speaks up to protest and speaks up in opposition to this agreement, urges members of the audience to stand up in protest against the city's actions, and tells the audience, right, if they agree with his viewpoint, to stand up. The mayor interrupts him, Assemblyman Alan Mansour, the then mayor interrupts him, saying, "We're not going to do that." In defiance of that order, still facing the audience, Acosta nonetheless said to the audience, "Do it, do it, do it." And essentially, the upshot of this decision was that the court found that the Costa Mesa code itself was problematic. It didn't meet this actual disruption standard. That essentially what the mayor did in this case constituted a form of viewpoint discrimination. He was essentially singling out a particular speaker because he disagreed with his viewpoint and the form of protest that he was engaging in. But again, unlike the White case, the White versus Norwalk case, the court in this case essentially held that the Costa Mesa code allowed for expelling someone who was engaging in activity that was short of actual disruption, something short of that, and that's why it was inherently problematic. There's a final case, and I know I'm probably at the end of my time here, but a case called Norse versus City of Santa Cruz, and I believe many of the speakers will probably address some of these cases, so I'm just setting this up for later discussion. In the Norse case, Robert Norse was ejected from a Santa Cruz City Council meeting and arrested after an incident in which he gave the council a silent Nazi salute during a council meeting. And essentially, the court held that the City of Santa Cruz's decorum standards were problematic because the City of Santa Cruz defined any violation of its decorum rules to be a disruption or disturbance, and then could essentially authorize them to expel someone from a meeting. And the court essentially rejected this definition and said that the city's definition, the way they construed their rules of decorum to include non-disruption, was constitutionally problematic. There are other insights, I think, that are worth drawing on from this case. And one, in a particular part of the opinion, the court noted there was an interchange following the show of the Nazi salute, where one of the council members was incensed, right, and was provoked, which led to a scene in the council meeting. And the court cautioned that a listener's reaction to speech is not a content-neutral basis for regulation. Speech cannot be punished or banned simply because it might offend a hostile member of a city council. Okay, so I'm going to stop there, but again, I think this sort of overview, and this is a 30,000 foot high overview of things, I think gives us some important guidelines to think about and principles to think about as we get into the details of this. I think we need to be cautious when we're imposing restrictions on what is perceived to be hate speech.